Chris Chapman, of course, the chairman of the Australian Communications and Media Authority. Well, moving on, and the New South Wales Supreme Court has just last week awarded a terminated executive payment of a $1.4 million bonus and 6 months' salary. It comes after an employee was terminated in response to allegations made against him by a fellow colleague who claims that he was forced to relocate to the UK as a result. Well, for more on this issue, we're joined by Joydeep. Now, so good to have you on the program. Thanks for your time today. Now, just give us some background on this case.
Yeah, it's a case we know well. We were actually acting for the executive in this particular case, so in this case successfully. What happened in this particular case was the particular executive had been involved in establishing a particular business here in Australia, being the offshoot of the UK business. Part of the deal whereby he and two other founders of the Australian business went into this venture was that if they stayed for a particular period of time and subject to particular goals being met, they'd each get a fairly significant bonus in the vicinity of about $1.5 million. Now, a couple of years down the track, after the relevant goals had been met, there had been some allegations made against the particular executive, accusing him of sexual harassment, and a decision was made by the employer to terminate his employment and to withhold that particular bonus payment from him, and also to withhold the notice entitlement that he had under his contract, which was for 6 months' pay. Now, interestingly, at the time, there was an offer that was made to the particular executive whereby they would give him a certain amount of the bonus they said as a goodwill gesture, subject to him signing away all of his rights. That was not enough for him, and he sought to assert through legal proceedings that his contract had been breached and he was entitled to the full bonus amount, he was entitled to his notice, and he was successful in the Supreme Court. So what this case was really all about was the response that the employer made to the allegations of sexual harassment. A very topical issue, of course, at the moment, because at the moment so many employers are understandably very apprehensive about any allegations that might be made by people within their organisation that they've been harassed or bullied. And what we're seeing a lot is that employers being very quick to respond to that, and while on the one hand that's a good thing to be responsive to those kinds of allegations, what this case proves is that if you stuff up that investigation process, and if ultimately you get it wrong, as the Supreme Court found that the employer did here, then you're going to face some very serious difficulties in terms of legal challenges from the person whom you might have dismissed.
So what should employers, I guess, be aware of then when they are actually performing these investigations into allegations? What do they need to take into account?
I think that the starting point is almost a philosophical one, that they have to presume that the person is innocent until they're proven guilty. And that's an important part of natural justice. The moment you start thinking that just because an allegation has been made that the person is guilty and has done the wrong thing, you're almost guaranteed to mess up the investigation process, because the way your questions are going to be asked, the steps that you take, will all be geared towards a manipulated outcome. You have to assume that the allegation or allegations are nothing more than that. They've got to be properly put in as much detail as possible to the person. They've got to be given every chance to consider what they want to say in response to it. You've got to take the time to consider those responses. If there are other people who are independent witnesses that could corroborate or not corroborate one person's version, they've got to be spoken to. It's never an easy thing to do a workplace investigation, but this case serves a stark reminder that if you get that piece wrong, it's almost as bad as not responding to the allegations at all.
In the first place, exactly. So when can an employer lawfully terminate someone?
Well, I think it depends firstly on what their contract says, but it also depends on certain entitlements that employers have at common law, which basically go towards conduct that would amount to serious and willful misconduct. So if an employee has engaged in theft or assault, or seriously brought the employer's reputation into disrepute, then the employer would have rights, subject to investigations, to terminate that employee's employment. Most contracts are written in such a way that an employer can terminate employment so long as they give a certain period of notice to the employee. But sexual harassment and those other kind of serious behaviours, if true and if proven, are grounds for what's called summary dismissal, in other words, termination without any notice of the particular employee.
Excellent. Well, we're going to have to leave it there, unfortunately, but thanks so much for coming in and thanks for your comments.
Thanks for having me.
Very good to clear up those sorts of matters.
Pleasure.
Thanks so much. Okay, well, coming up we will